I just want to again welcome people to the conference, Citizens United versus FEC after 5 years. I'm David Keating, president of the Center for Competitive Politics. Again, I'd like to thank the Cato Institute for hosting the event in their facilities today, and with all the help with the audiovisual support and organizing here, and in particular, John Samples, who's done a lot of great work at the Cato Institute on campaign finance reform issues and many other things, so thank you. Our next panel is, by reading the dissent in the Citizens United decision and a lot of the popular left of center writings, you might think that liberals don't like Citizens United, but in fact there are many liberals who do like it, and our next panel is going to discuss should liberals support Citizens United. Now, by that I don't mean they're going to sign up and support the next Hillary the movie sequel, but Citizens United, the concepts in the Supreme Court decision. Our interviewer for the panel is Stuart Taylor Jr. He's an author, freelance journalist, and Brookings Institution non-resident senior fellow. He's written a lot on legal and policy issues. He's a National Journal contributing editor, practicing lawyer, and his focus is primarily on constitutional law, media law, and the Supreme Court. Our panel, it consists of Ira Glasser, former executive director of the ACLU, legendary executive director and basketball player. And he really, from everything that I've read about his tenure there, he built the ACLU from a relatively small organization as things go into a powerhouse across the country. Wendy Kaminer, also on our panel, she's an author, lawyer, social critic, and contributing editor of The Atlantic, and I highly recommend you go and look up some of her articles. She's always interesting. So she is also a former board member of the ACLU and currently serves on the advisory boards of the Foundation for Individual Rights and Education and the Secular Coalition for America. And then we also have Gabe Rottman, legislative counsel and policy advisor at the ACLU. I've worked with Gabe the last couple of years, and the ACLU has a terrific advocate here in their Washington legislative office where he focuses on the First Amendment. So he is often the fellow you will see representing the ACLU before Congress, and he's also done some great work on the proposed rules that the IRS has issued and is going to have to reissue. So without further ado, turn it over to you, Stuart, for the interview of the panel. Thank you.
Thanks very much. Thanks for having me, and thanks for having this great panel. I'll start. I'm going to ask questions roughly in this order, as going from left to right, or alphabetical order from my left to right. And I'm going to start with asking the same question of each of you. That won't, since the name of the panel is "Should Liberals Support Citizens United?" My first question is for each of you is, well, should they?
Well, I'm not accustomed to being brief, so I won't just say yes. Mm-hmm. But the key question that always has to be asked and answered, and that very few people do, when you're contemplating speech restrictions, is who's going to get to decide them? Who's going to get to decide which speech should be restricted? And the one thing that is almost always the case, at least with respect to liberals, is it isn't going to be them. It isn't going to be us. It isn't going to be you. It's going to be whoever has political power. And many liberals, many people on the left who have been consumed by outrage over the Citizens Union, the Citizens United decision, aside from the fact that very few of them even understand correctly what the Citizens United decision was. Most of those consumed by that sort of outrage are assuming, they have an expectation that if they can reverse the decision or pass a constitutional amendment that changes the First Amendment and reverses the decision, that they will be in a position to decide which speech, namely the speech that they hate, will be restricted. And that is completely delusional. Forget about as a matter of First Amendment doctrine. It's completely delusional. Liberals and people on the left in this country have been more victimized by speech restrictions over the entire history of our country than any other political segment in our country. And if you're going to reverse Citizens United such that the organization Citizens United cannot run a film critical of Hillary Clinton, then you're also going to have to contemplate that Hillary Clinton's own book, Hard Choices, will be subject to the same restrictions, or could be subject to the same restrictions constitutionally, should she become a candidate for president. For people like Planned Parenthood who want to criticize Rick Perry because of his positions on reproductive freedom, they will be restricted. They will not be able to run ads or anything else. For the Sierra Club, if they want to criticize Marco Rubio for being a climate change denier, they will be prevented from doing so. The ACLU could be prevented, not could be prevented, in fact, on the basis of campaign finance laws, was momentarily prevented from criticizing Richard Nixon on school integration issues, from criticizing Ronald Reagan on a wide variety of civil liberties violations as we saw it back then. And campaign finance laws were used to try to restrict us. But for the fact that we were able to prevail in litigation, they would have restricted us. If labor unions want to criticize Scott Walker, should he become a candidate again, they would be restricted from doing so. The thing about speech restrictions is that the first target of such restrictions, which you might like, is never the last. And speech restrictions are like poison gas. It seems like a terrific weapon to use when you have this target that you don't like right in your sights. But the wind has a way of shifting, and it always does, and it doesn't usually shift in the direction that liberals like or the people on the left like. So when The Nation magazine editorializes, as it did shortly after the Citizens United decision, for a constitutional amendment that would rewrite the First Amendment in order to reverse the Citizens United decision, they commit political suicide. I mean, the first victim of such a constitutional amendment would be The Nation magazine. Almost everything that they have published criticizing public officials over their 100+ years history would be subject to the kind of restrictions that they are editorializing in favor of. It is beyond the question of First Amendment doctrine. It is politically and strategically the stupidest thing I have ever seen any group of Americans, whatever their political ideology, propose. They are the very last ones on the left who ought to be doing this. And if they imagined that the restrictions that they put into place were restrictions that were controlled and decided by people named Joe McCarthy or Dick Cheney or Richard Nixon, they might think differently, but they never do that. When people propose restrictions on speech, they always imagine that they are going to be the ones to decide how those restrictions will be used, and they never are. And that's the reason why, as Joel Gore said, Citizens United was probably the best First Amendment decision in the last half a century, and the best for liberals and the best for the left, but they're the last ones who know it. It's a very well-kept secret, and we need an Edward Snowden for campaign finance facts. We don't have one yet.
Thank you, Wendy. Is there anything to add to that on this question of why liberals
I know, I was
would like
just saying
it?
to Gabe,
If not, I've got other questions I can ask.
It's always problematic following Ira because he often doesn't leave much to add. But let me just say a couple of quick things to amplify what Ira has said. He's talked about the fact that citizen advocacy groups, whether it's Planned Parenthood, the Sierra Club, ACLU, or the NRA, had their rights to speak restricted under McCain-Feingold and restored by the Citizens United case. What people on the left one of the many things they don't understand about the Citizens United case and about the history of campaign finance restrictions, at least going back to recent history, at least going back to McCain-Feingold, is that these restrictions on corporate spending don't just apply to what they think of as the big bad business corporations who don't represent our interests. They apply to all of the advocacy groups that they join, that they support, all of the groups who amplify their voices. Like many of you, I regularly get blast emails from politicians, and lately I've been getting blast emails from, at least half the Democratic caucus: repeal Citizens United, get rid of outside money, get rid of dark money, restore the right of regular people to speak. And what these regular people don't realize is that Citizens United restored their right to speak because it reaffirmed the right of all the groups that they belong to. Rich people didn't really need Citizens United as much as ordinary people did. Rich people can buy media companies, as they do. I mean, the super rich people. If you look at who owns the Washington Post or the Boston Globe, or even the New York Times, if you look at, at Murdoch and Fox, I mean, the plutocrats who are the target of so much fear and loathing on the left, they don't need this case, really, because they can always buy something that will give them a media exemption. The people who need it are the people who, one, can't afford to make really large contributions either to candidates or party committees, much less to super PACs. They're the people who buy megaphones collectively by paying membership dues or making small contributions to all the advocacy groups that represent them. And the rights of those advocacy groups are what Citizens United protected, in part. Now, the next question that I'm often asked with this is, well, what if we could distinguish between the business corporations and the not-for-profit corporations? That's a nice idea, but in practice, you really can't. And put aside any First Amendment questions about the values of commercial speech and how you distinguish between commercial speech and political speech. It's certainly in an age of media conglomeration, when you have corporations owning media companies. I mean, that's just one example of how difficult it is to make these distinctions. And I'll stop there and let Gabe pick up whatever we've left.
Feel free to do that, or if you think it's been exhausted, I'll ask you something else.
I'll make one additional point, and I'll be very, very quick. Just as a matter of legislating, the sausage factory is an imperfect place. It's extremely difficult to get things right in Congress. And the laws that were at issue in Citizens United sort of embody that. And if you want to talk about the biggest danger to free speech in how we set policy in this country, how we make laws, the biggest danger is twofold. It's complexity and ambiguity. And at the heart of the Citizens United case was probably the most complex and ambiguous question that you need to answer in order to enforce these laws, which is, if you have a communication which doesn't say vote for or against a candidate, but talks about policy and issues, how do you determine whether that communication is a sham? It is, in fact, a covert exhortation to vote for or against a candidate. It's exceedingly difficult to do. And if you want to protect free speech, especially because of the fact that progressives, liberals, especially progressives in the strain of the ACLU, are a minority in this country, a significant minority in this country. And I think it's exactly right that when you give the government the power to draw these very difficult lines, these very blurry lines, you're opening the door to you're opening the door to very poor outcomes for freedom of speech and for open and robust policy debate. I mean, that is at the heart of Citizens United, and it's at the heart of a lot of the questions that we're going to be talking about today.
Since you were last and brief, let me ask a follow-up on that. I'm going to quote a statement by Richard Hassan, who now is author of the widely read election law blog. He wrote in 1999, quote, "The principle of political equality means that the press, too, should be regulated when it editorializes for or against candidates," end quote. Was he right? And where does Citizens United fit into that scenario?
mean, I respectfully disagree. I think that a lot of folks have actually argued that Citizens United should have been decided under the press clause, not the speech clause, and it would have made things a lot easier. I think the problem there is that during oral argument in that case, the government admitted that under their theory of the case, you could restrict one of these books that the candidates write before the election, Hard Choices or Dreams of My Father. You could regulate the actual publication of a book. So, and there really are no limiting principles to that. So if you were to write a fictional book like Primary Colors, you know, a loosely disguised book about the first Clinton campaign, if that book is critical, or if that book is critical of a candidate, or if it praises a candidate, does that mean that it's actually a campaign communication? So again, you're talking about very complex, very ambiguous lines and drawing those. And when you're talking about regulating books, it's an exceedingly dangerous thing for free speech.
Right.
Stuart, can I just add to that for a moment? Richard Hazen has a blog. So doesn't that make him a journalist? And
sure.
Wouldn't this rule also apply to him then? Because
Sure.
he writes on politics.
Well, you'd have to ask
I'd
him.
have to ask him. But it's a good example of the principle.
He's a
that
clever
Ira has-
fellow, so he
Poison
might
gas.
he might surprise you with the answer. Ira, speaking of the media, if all a person knows about Citizens United and campaign finance law generally is what they could learn from the New York Times, the Washington Post, and NPR, to pick three examples, how accurate would their picture of reality be?
Well, Mary McCarthy once said about Lillian Hellman that every word she wrote was not true, including and the. And that's how I sometimes feel about the New York Times coverage of Citizens United and campaign finance reform. Speaking in the most moderate terms I can think of about it, the Times coverage in their editorial pages, in their columns, and in their news stories of Citizens United and its consequences has been willfully intellectually dishonest. They know what they're doing. They know that it's wrong. I have personal reason to know that they know that it's wrong, and they do it anyway, and they defend it because it's in the service of a political agenda that, fortunately enough, exempts them from the consequences of the speech that they want to repress. You know, the whole reason that there was a media exception, an exception from something called media corporations, which nobody exactly knows what it is, and the McCain-Feingold law didn't define it with much precision, was because if they tried to include the Times and the Washington Post and networks within the restrictions on all other corporations in McCain-Feingold, those media corporations would have attacked the law so brutally that it could never have passed. This was an intellectually dishonest exception to begin with, and it's one which the Times has hid behind. You know, if you ask the Times editor, well, why can you in your editorial columns explicitly support one candidate and attack another one, which is, as anyone who's ever run for office knows, is of enormous value. Why is that permissible? But if I want to go on television and say the same thing, I commit a crime. Why is that? Their answer is, we're the press. You know, which is not only wrong, but it is an intellectually dishonest response. Because there is no First Amendment right to expression that adheres only to the press and not to a person distributing a leaflet or a person wanting to say something on radio or television. And it's just another example of the delusion that a lot of kind of good government folks have always had, and this is not the only example of it, and thinking that the restriction only applies to the bad guys. It doesn't apply to us because we're not the bad guys. And that's not something that ultimately can be sustained. The reason, that exchange in the oral argument that Gabe referred to, where the government's lawyer is asked, well, if we can do this to Citizens United's right to run a film on television, can we do it to a book? And the answer was yes. McCain-Feingold didn't do that, but constitutionally, you could do it. So the fact is you can't sustain those kinds of distinctions for very long. And the people who have the most interest in opposing those kinds of restrictions are the people who are going to be most vulnerable to be targeted by them. And that, in this country, is going to more often be on the left than anywhere else. So for them, to circle back to the theme of this panel, for them to be the ones advocating this. For Al Franken to send me 300 emails a day asking me to support a constitutional amendment to rewrite the First Amendment. Al Franken, who wouldn't exist if it were not for the First Amendment, whose books that could be the subject of the restriction he is now supporting, or what launched his political career, for him to be saying this is beyond opposing a civil liberties principle. It's just the most strategically dumb thing I can imagine. It's like the black students on campus who supported hate speech codes without understanding that if those kind of hate speech codes that they were supporting had been enforced in the 1960s, Malcolm X and Eldridge Cleaver would have been their most frequent victims, not David Duke. People never understand that. That is, if I learned one thing about how the First Amendment works in the public imagination over my decades of the ACLU, it was that everybody supports free speech so long as it's theirs.
Great. By the way, I might toss in one little noticed aspect of Citizens United, unless I misrecall, is that the freedom of the press clause in the First Amendment gives the institutional media precisely 0 rights that everyone else doesn't have under the freedom of speech clause. Right. And that's the law of the land. So the only thing that protects the institutional media from whatever the campaign finance laws are is what you mentioned earlier, that Congress is afraid of the institutional media, so it will exempt them. Wendy, you had an eye-opening article yesterday, I think it was, explaining that many of the dire predictions and claims about Citizens United are simply wrong. For example, the prediction that political spending by for-profit corporations would explode, and NPR's recent claim that it opened the door for secret donors to make big dollar contributions. Could you detail that, please?
Yeah, you asked initially what people would learn about Citizens United from the mainstream media. They would learn that it greatly increased corporate, the spending of business corporations. They would learn that it enabled dark money. They would learn that it gave rich individuals, mega-rich individuals, the right to make dark money contributions. They might learn that it eased restrictions on coordination. They might learn that it allowed corporations to make direct contributions to candidates. All of those facts are false. There's a very interesting report that came out of the Brennan Center, which is a very strong advocate of campaign finance restrictions, a very strong opponent of Citizens United. They issued a report, a 50-year anniversary, a 50-year anniversary report on Citizens United, and it's fascinating. It gives you a real window into the way liberals who sort of understand the case and have some understanding of campaign finance still rationalize their desire to repeal Citizens United. The Brennan Center acknowledged that its own predictions that Citizens United would greatly increase spending by business corporations turned out to be inaccurate. It said that and it also acknowledged that its prediction that campaign spending overall would greatly increase was inaccurate. I think it stated that campaign spending overall stayed relatively flat. It said that the greatest increase in spending has come from an elite club of very wealthy individuals, which may well be true. And then, so it acknowledges all of this, and then it still goes on to say, we need to repeal Citizens United. Now, I'm paraphrasing, but this is essentially the gist of it. We need to repeal Citizens United so that we can tighten rules on coordination, tighten restrictions on coordination, so that we can eliminate dark money. And there was one other goal, which I'm forgetting, which also had nothing to do with Citizens United. I mean, the point is that they're saying, we want to repeal Citizens United so that we can accomplish all of these things that Citizens United is either not responsible for or doesn't prevent. The other thing was transparency. People generally blame Citizens United for transparency. Well, the court in Citizens United spoke approvingly of disclosure. It specifically upheld disclosure requirements, as did the Federal Appeals Court in the Speech Now case. The individual right to spend was established in Buckley v. Vallejo. The Citizens United case had really nothing to do with coordination. So, you could repeal Citizens United, it wouldn't advance any of their goals. And you can advance their reformist goals, some of which I support, like the need for additional disclosure, without amending the First Amendment and without reversing Citizens United. So it is really a mystery to me why people at the Brennan Center, who I credit with understanding all of this, can make these claims. Let me make just one more quick point. It is not a mystery to me why politicians, why Al Franken and his colleagues continue this crusade against Citizens United. Even some of them may well understand that their generalizations about the case are not quite true, because for a lot of people on the left, this case and opposition to it has become a political organizing tool. I mean, I was at a debate about Citizens United a few years ago that the American Constitution Society was sponsoring, and I think it was somebody from the Brennan Center who said quite forthrightly and quite approvingly that Citizens United is a political meme. And that is very destructive, because it's not a political meme. It's a case. It's a very important case about First Amendment principles. And if you want to, there are problems, I believe, with the campaign finance system, and if you want to solve them, you have to understand it. And the political organizing around Citizens United disseminates gross misunderstandings of the case, gross misunderstandings of the system, and gets in the way of remedies.
Thanks, Gabe. Before Citizens United, corporations and unions could legally buy issue ads attacking or praising candidates, so long as, and attacking them pretty directly, so long as they avoided elect Smith, defeat Jones, words of express advocacy, it's called. Given that, and they could do it without disclosing where the money came from, right? Given that, why is Citizens United such a big deal? I mean, can't you get most of the bang for your buck by saying Kaminer's no good, that you could get by saying defeat Kaminer?
Well, I mean, under McCain-Feingold, you couldn't actually, so corporations, labor unions couldn't do express advocacy, so independent expenditures, and they also couldn't do electioneering communication, so simply mentioning the name of a candidate within a certain period before an election or primary. In the Wisconsin Right to Life case, the Supreme Court narrowed that and said that the electioneering communications prohibition would only apply to the functional equivalent of express advocacy. So even if you didn't use express, the magic words, vote for or against, if it was clear on its face that it was asking you to vote for or against a candidate, it qualified under the prescription. Citizens United reversed. Citizens United went the next step and overturned a case called Austin v. Michigan Chamber of Commerce, which allowed bans on independent expenditures. So in doing that, it also got rid of the prohibition on electioneering communications, which is what ACLU filed an amicus brief asking the court to do. The short answer to your question actually is sort of separate. I think Citizens United was the capstone of a decade-long fight over exactly this question of, can you constitutionally restrict the ability of nonprofit corporations like the ACLU or NRA to mention candidates when engaged in issue advocacy. So I think for that reason, I think it's a great decision. In terms of, and when he was mentioning growth in campaign spending, I do think if you look at the trend line, it's not like you've seen explosive growth after these various cases. There's no question that campaigns are becoming more expensive because there's more people, there's more TV screens out there, right? Not just broadcast television, not just cable, but the internet. So campaigns it's more expensive to get your message out. I'm not sure that you've seen shifts in the money, right? So you've seen money go away from the parties into outside groups, which I do think is true. But if you look at overall campaign spending, I'm not sure that you've seen explosive growth. So if the original question was, is Citizens United a big deal? I'm not sure that it has unleashed the torrent of corporate spending, directly into campains that you see a lot in the press.
Thank you. Ira, could you want to address the same question?
Well, the reason why Citizens United is a big deal is not because of what it did. Almost all of the parade of horribles that liberals trumpeted in its aftermath were sure to happen, have not happened. The reason why Citizens United is a big deal is not because of what it did, it's because of what it didn't do. If it had been upheld, then you would have had a parade of First Amendment horribles that we've been talking about. The thing about the express advocacy bleeding into any mention of a candidate, what Gabe says the law calls electioneering communications, which is itself a misnomer. Because if I say, if I issue a statement urging Richard Nixon not to oppose school busing for integration, how do I do that without mentioning his name? And why does that become an electioneering communication? Because I mentioned his name. The campaign finance reformers, and they really ought to be called fundamentalist zealots, because that is what they are. They have not said this about any mention of a candidate is the equivalent of express advocacy in terms of what you can restrict. That is not an invention of McCain-Feingold. It was a culmination, not just of 10 years, but of 40 years. I mean, what I described as the ACLU being restricted because we issued an open letter to Richard Nixon when he was president, urging him not to oppose school busing for integration. I didn't make that up. That was a real case. We tried to run an ad in the New York Times in 1972 in the form of an open letter to Richard Nixon on school integration. It was what the ACLU does. I mean, we by our own policy have never, in almost 100 years of the ACLU existence, have never supported or opposed a candidate for elective office. And not because we're prevented from doing so by the law, because that's the ACLU policy as a nonpartisan organization. We've never done that. But in terms of criticizing public officials for what we regarded as their breach of civil liberties principles, how exactly do you go about doing that without using their name? So in 1971, that was permissible, according to the campaign finance reformers. But in 1972, when Richard Nixon was running for office, it became an electioneering communication. They didn't call it that back then, but we had to go to court to get the right to publish that ad. And And what happens now is that when McCain-Feingold said, we're finally going to close this loophole, we're going to say an electioneering communication is anything that mentions a name, because if you mention the name of a candidate who you are praising or criticizing during a period when they are running for election or re-election, you can influence the outcome, and therefore it's the same thing as express advocacy, and it can't be permitted because it's corrupt. That has happened for 40 years in different guises and different forms. The very, very, very first victim of the first campaign finance laws in 1971 were three kind of almost laughable lefties. I then thought they were very, very old, but they were probably about as old then as I am now. And they came wandering into my office at the Civil Liberties Union in 1971, and they said that they had been enjoined by a federal court from publishing an ad in the New York Times that criticized some members of the Senate for voting for the bombing of Cambodia, and praised others for opposing it. And I said, no, you can't have a court order against that. You have a First Amendment right to do that. They were just sort of three private individuals, one of whom had a lot of money and didn't know what to do with it. And they thought running a two-page ad in the Times would be a fine thing to do. Aside from the fact that the ad itself was almost unreadable, that was my first acquaintance with the campaign finance laws, the Federal Election Campaign Act of 1971, and because that was the basis that the court cited for enjoining them. And I read that law, and it basically said, as the electioneering communication stuff does now, that in an election year, if you criticize or praise one candidate and mention his name or her name, it's the equivalent of express advocacy. If you criticize them, you're opposing them. If you praise them, you're opposing their opponent. And there have been scheme after scheme for 40 years of trying to extend the restrictions against express advocacy to anybody who mentions a candidate during what is called an election period. McCain-Feingold was only the culminating part of that. And the campaign finance reformers have been after that, what we regard as free speech, as core free speech. I mean, if you can't criticize a public official for something that you don't like that they did, what is left of the First Amendment? What we regard as core free speech, they regard it as a loophole to be closed. And they have said it, and Citizens United basically said you can't do that. And that's why it was a great day for the First Amendment on that decision. And the fact that the four dissenters all sort of have a reputation as being liberals on the court does not change the fact that in that case, they voted against the First Amendment.
Wendy, I, as a non-expert, have often been confused about what the disclosure rules are. Could you explain in a way that even I can understand how the disclosure rules work for corporations, unions, individuals, super PACs, little PACs, express advocacy, issue ads? How does it all fit together?
Stuart, I'm going to give you a very short answer, which is no. I can't explain it, and I wouldn't even try.
Just what the rules are?
Well, I'm serious. I wouldn't even try to explain it without consulting an election lawyer. And that, I think, reflects another major problem with the campaign finance regime. It is so incredibly complicated that if you're engaged in campaign funding at all, you really can't do anything significant without consulting a lawyer. I think even Larry Lessig, who had his own PAC going in the last election, at least had allegedly violated some disclosure rules. I mean, Richard, you're nodding your head. It's incredibly complicated. I wouldn't begin to try to explain it off the top of my head. If there's an election lawyer here who is steeped in the details of this, perhaps he or she can explain it to us.
Well, that must be Gabe. If you are that man, step forward. If not, is there anything about the current disclosure rules? Is there
open your mouth?
is there anything about the current disclosure rules that you would like to see changed?
Well, so actually, the answer to the question of what are the disclosure rules, it's actually a lot of disclosure. The dark money controversy really deals only with 501c tax status groups, and they actually need
What are they, for the benefit of my mother if she's listening?
So 501, so they're named after the section of the code. C3s are charities, and they can't engage in they can't do politicking. They can't actually take out ads saying vote for or against this person. I'm sort of oversimplifying a little bit, and then C4 groups are social welfare groups like the ACLU. And they have to disclose to the IRS, but because of the civil rights cases where Southern segregationist states tried to force groups like the NAACP to disclose their membership lists in order to run them out of the state, those member disclosures for C4 groups are kept secret. There's one other. There's one other scheme where C4 groups can send money to super PACs. Super PACs, full disclosure. But when the super PAC does its disclosure to the FEC, it just mentions the name of the C4, unless the money has been earmarked actually for an independent expenditure or electioneering communication. So in fact, actually, there's a significant amount of disclosure, and all of those rules were upheld by the Supreme Court and Citizens United. Then there has been additional calls for disclosure in the last two Congresses. I think it's the last two Congresses that would significantly extend the blackout period before an election. When if you engage in an electioneering communication, simply mention the name of a candidate, you have to disclose your donors as a C4.
Can I just add to that quickly? The dilemma for advocates of disclosure, and I consider myself one of them when it comes to really large contributions. Anonymity is an important value, but I think that when you're talking about large contributions, where wherever you would draw that line, it's a little arbitrary. The right of people to know can trump the right to anonymous speech. But the real dilemma is the problem posed by these, what are essentially partisan electoral groups that are benefiting from the anonymity that is, I think, rightfully extended to advocacy groups or social welfare groups. And Ira can talk about this in more detail and more knowledgeably than I can, but there's a real problem with the inability of the IRS to enforce the laws and the inability or the refusal of Congress to address this problem. And I'm going to throw the rest of this to Ira, because I think it's an important point about dark money.
Sure, and let me add one specific thing to it, if you weren't going to cover. Dark money, that's a popular phrase. I think people who know what they're talking about think it refers to the ability of wealthy people to give money to groups that take out issue ads without their identities being disclosed. Is the current state of the law on that okay, or do you think there should be more disclosure?
Well, when Wendy said the real problem was the IRS with respect to that, that is correct. And the real difference between 501c3 and 501c4 organizations, from a tax point of view, is that neither 501c3 organizations or 501c4 organizations can do political work according to the law. The difference is that if I make a contribution to a 501c4, it's not tax deductible. If I make a contribution to a 501c3, to what's called a charity, it is tax deductible. And the real difference is the amount of lobbying that each of them can do under the law. But the fact is that the reason why almost every 501c4 nonprofit cause organization created a 501c3 as a companion organization. The ACLU did that back in the 60s, was because 501c4 organizations could not accept large contributions. I mean, our average gift to the ACLU was $20 at the time, and maybe is a little higher now, but not much higher. And if you wanted to solicit and somebody wanted to give, if I solicited Stuart Mott to give us $50,000, he wanted it to be tax deductible. So we had to have a C3 organization in order for him to do that. But more than that, the 501c4 tax law requires that if a contribution is made to a C4 in excess of the individual tax-exempt amount for making a gift, it's subject to a gift tax. That's in the statute. So if somebody wanted to make a large contribution to a C4, whether it's Sheldon Adelson or George Soros, they would have to pay a hefty gift tax. The IRS, somewhere along the line, stopped enforcing that. That is, in another modest word, lawless. It violates the statute. Congress created a different tax-exempt organization called 527s for the express purpose of receiving political contributions and making electoral expenditures. That's where all the money went. That's where George Soros contributed his $27 billion in 2004. That's where Peter Lewis contributed his $27 billion. I didn't hear a liberal word of opposition to those big contributions because those were ours. But if the Koch brothers would have done that, the world was caving in. And I haven't heard any liberal objections to what Tom Steyer is doing now either. But what happened after Citizens United, precisely because of disclosure, is that because Citizens United approved disclosure, people who were making large contributions to the 527s were afraid that they were going to be subject to disclosure. So all that money started to flee into 501c4s, where it wouldn't have if the IRS had enforced the gift tax. And the 501c4s, which were organizations like the ACLU or Planned Parenthood or the NRA or any of these organizations that had existed for years on relatively small contributions and had created C3s alongside them to receive the large contributions, those organizations like them suddenly became receptacles for money that was supposed to go into the 527s, ended up going into the 501c4s in the hope that the NAACP against Alabama line of cases that had protected the anonymity of contributions to the 501c4s would protect their large gifts as one citizen. So it's precisely because Citizens United approved disclosure, and the 527s, which were designed for political electoral money, would have been subject to disclosure, that this money started to bleed into 501c4s in the hope that since the IRS was not enforcing the gift tax, we can do it without penalty, and maybe we'll be protected there against disclosure as we would not in 527s. This is a problem that's been entirely created by the IRS.
I think we're almost out of time. In the interest of equal time, I'm going to allocate whatever we have left to Gabe to say whatever, to answer any questions he thinks I should have asked that I forgot to.
I guess I would just go back to the fundamental problem, that I was mentioning earlier, which is when you're talking about campaign finance laws, election laws, and also the tax laws as they apply to political activity, it's very, very difficult just because of the way that Congress works and the way that state legislatures work. It's very difficult to throw out the bathwater, right, and maintain the baby. And by that I mean it's very, very difficult. It's an exceedingly difficult exercise for the government to distinguish between a sham issue ad and a true piece of express advocacy. That problem, that practical issue, infects all of the campaign finance laws that we've seen over the past since 1971. And I think that is the fundamental fundamental problem that progressives, liberals, folks on the left should be concerned about, because when you give the government the power to make those types of decisions where there's really no boundaries, really no guidelines, the government is, as we've seen historically, the folks that are going to end up on the wrong side of those bad decisions are going to be people on the left.
Good. Thanks to all of you. Great discussion. Thanks, Steve, for hosting us.